We are laymen.
Good afternoon, everyone. Welcome to the 8th lecture of the JGLS Judicial Services Examination Lecture Series 2021. It is an honor for us to have Mr. Nipun Saxena, Advocate Supreme Court of India, delivering the lecture on the Indian Contract Act and the Specific Relief Act. At the outset, I would like to apologize for the little delay that we had in beginning with the lecture. It was a technical glitch that our speaker was facing. He will be joining us shortly. But before we proceed with the lecture, I would like to take this opportunity to read Advocate Saxena's bio. For reading it has always been a source of motivation for me. I'm sure it will motivate and inspire our attendees as well. Advocate Saxena is a practicing advocate in the Honorable Supreme Court of India and frequently appears in high courts and other judicial and quasi judicial tribunals. Having apprenticed under the Additional Solicitor General of India for CBI and National Investigation Agency matters, he has assisted in various high profile cases. On the civil side, he has appeared in matters ranging widely from the real estate to company matters, security transactions, joint Hindu family, public trusts, and registered societies, customs, excise, and has acquired expertise in international investment arbitration matters. On the criminal side, he appears in special legislations, including the Anti Dacoity Act, Prevention of Corruption Act, CBI matters, money laundering matters, Official Secrets Act, and IPC. His appearance in the PIL on Delhi gang rape case entitled Nipun Saxena and Another versus Union of India and Others has led to the creation of Victim Compensation Fund and a robust mechanism for rehabilitation and compensation of acid attack survivors, rape survivors, and led to the establishment of one-stop crisis centers in every district in India. The Supreme Court of India also passed directions for the protection of identity of minors and women who are sexual assault survivors. The Supreme Court has passed a volley of directions pertaining to protection of identity of rape survivors. His interest in the field of substantial questions of law of general public importance and public policy legislations has earned him critical acclaim. His critique on the Communal Violence Bill was not only documented by the Parliament of India in its volume, but was instrumental in the formulation of the new bill, which has replaced the previous one. While as a student, he spearheaded in the ambitious project called the Tihar Prison Advocacy Project, a joint initiative of the Legal Services Committee of the National Law University Delhi and the Tihar Prison Authority, where, for the very first time, students appeared in the courts of law and secured bail for accused under trials who had been languishing in prisons for an inordinately long period of time. In addition to being a visiting faculty at the National Law University, Delhi, Advocate Saxena has been conducting arbitrations across Europe in various institutional arbitration forums. He frequently advises various governmental organizations, companies, and societies, trusts, and persons on critical issues. Some of the current cases that he has appeared for in the Supreme Court of India include the Kerala Bar License case, the National Herald case, the constitutionality of criminal defamation, the GIP negligence case, Royal Jaipur Palace dispute, Aadhaar cases, Vyapam cases, Air India case, Centro Trade case, COVID PIL, to name a few. We now have with us Advocate Saxena, who has finally joined us after the glitch. And we welcome Advocate Saxena, and the floor is yours, sir.
Thank you so much, Ms. Panigri. It's been an absolute pleasure to be a part of this wonderful session, a series, if I may say. I've been invited to speak over some nuances pertaining to contract law and the specific relief act. So, without further ado, since there's this a lot of time has gone by, primarily from my end, so we'll commence. To begin with, our initial basic formative understanding of contract law, I think it's very, very critical to break it into how does one enter into a contract? Secondly, how does one assume the capacity to enter into a contract? Thirdly, the steps of entering into a contract. The fourth part, which I think I must also emphasize, is certain aspects related to the performance of contract. Now I have been given to understand that I am to sort of talk about all the provisions which which line up to about 250 odd provisions, including the contract and specific relief act. So which is of course humanly impossible in a period of 1 hour. So what I'll do is I will only focus on the key aspects which I think are important, and then I will leave it to the wisdom of my audience to figure out the rest, right? All right. So let's begin with what exactly is when I say when I try to define contract, right? Very simply put, contract is an agreement which is enforceable by law. Now, when you say agreement, the agreement itself has particular constituents. Okay? There has to be a valid offer, there has to be a valid acceptance, there has to be a lawful object, and it has to be on the basis of consideration. Right? Now, unless and until all these 5 formative elements or ingredients are present in an agreement, the agreement suffers from what you call formative defects or formative difficulties. Which is to say what? Which is to say that if any of these elements or any of these ingredients are absent in an agreement, then that agreement is not an agreement within the confines. Right? Once you have all those 5 elements, then if an agreement is enforceable by law, then that is called a contract. But let's take a step back, right? Contract is an agreement between who? Between 2 or more individuals, right? Or between 2 or more entities. It could be a non-state actor. It could even be state, because let's say under Article 300A, the government of India is also capable of entering into contracts, and by that logic, most of the bilateral treaties are nothing but contracts which are being entered into between nation states, right? In investment state or investor state dispute arbitrations, one of the major ground which is often being taken is the capacity of the state or capacity of the person who is entering into a contract with the state. Of course, that question is no more res integra, because the Indian Contract Act recognizes that even state can enter into contracts with a non-state. Now, therefore, we understand that contract could be entered into by a legal person, which includes trust, which could include society, it could include a corporate or an incorporate body, it could be entered into by associations, by person, by companies, corporations, by statutory bodies, by state. So it covers a wide gamut of entities that can enter into. Now, more importantly, who has the capacity to enter? Firstly, the person who is entering into a contract must be a major, because we understand that when corporations or when let's say non-natural persons are entering into contract, it does not mean that there is a company which is signing something, because you need a natural person to sign something, right? Or to communicate their acceptance or consent. So for that, there are these authorities which are represented through their authorized representatives, who would also be natural persons. And therefore, everything boils down to whether that natural person who is affixing his or her consent on paper or otherwise would is in a position to enter into that contract, has the mental capacity. Now, there are only 2 things that one looks at when we are considering whether somebody has the capacity to enter into contract. Is first, that the person must have attained the age of majority. Now, age of majority is nowhere defined under the Indian Contracts Act, but age of majority is defined under the Indian Majority Act of 1875, which clearly says that if neither of the natural guardian of a person are alive, in that case, the age of majority is attained at the age of 21. However, in case either of the natural guardians, which is parents, are present, in that case, the person attains age of majority at 18. Either or. It's only a situation where neither of the 2 parents are present that a person will only attain age of majority at 21. Now, these questions are all questions of fact which have to be proved by leading evidence. I'm not getting into the entire debate of how to prove whether a person is, a major or not, but having understood that, all right, that's one of the conditions, let's look at which is the second most important condition. The second most important condition is that the person must be of sound mind. Now, what is soundness of mind versus what is unsoundness of mind? Soundness of mind is not to be taken or not to be understood with the medical definition of soundness of mind, because clinically speaking, all of us face some or the other deformities, as they call it, which would imperil our wisdom in some sort. However, the legal threshold of determining whether you are or whether a person is of sound or unsound mind is very, very low. The legal threshold is if the person who is affording their consent is in a position to understand A, the nature, and B, the consequences of the act that they are about to do. Just to give you an example, I am about to dispose of a property, an immovable property, which is about 7 crore rupees for 7,000 bucks, right? Now, can I do it by way of a contract subject to circle rates and everything? Yes, I can. There is no embargo. However, am I or do I have the mental capacity to understand that by affixing my signature on this registered instrument and by going to the registrar's office, so what am I doing? I am hereby alienating my own property to which I am the owner and possessor, and I'm sending it to somebody else. I'm conveying the entire title, ownership, possession, and all easementary rights arising out of that immovable property and conveying them to another person. So am I understanding the nature of what is being done? Yes. Do I understand the consequences of it, of this particular agreement? If this agreement were to be enforced, I will no longer have any claim to my own house. And despite knowing all of this, I have entered into that contract. Then and only then it could be, it could be presumed that I had the mental capacity or that I was of sound. Now, interestingly, many times soundness of mind is a question which is debated. Now, this question not only comes under contract, but usually this question comes when somebody is hypothecating or somebody is conveying the property through will, right? In all those questions, the mental faculty of a person remains and continues to remain a question of fact. And that has to be established by leading evidence, whether the person had the mental capacity or not. Let's talk about certain permutations and combinations around this concept. Let's say there's a person who has mental capacity for some time and does not have for the rest of the time. So what happens in such cases? The requirement of law is, and that's a settled judicial precedent since Privy Council days, is that what has to be seen is at the time when the contract is being entered into, the person had the requisite mental capacity or not. If it is established that at the time when the contract was being entered into, the person did not have the mental capacity to enter into a contract, then for all intents and purposes, that contract itself becomes void, right? Now, just to give another example, suppose a person has epileptic fits. And while that person was having an epileptic fit, somebody took his thumb impression and affixed it on paper. Now, can that person subsequently say that my consent was not a valid consent? And please understand that this consent does not arise out of the 4 principles which form in section 14, 15, 16, 17, 18 of Contract Act. These are not those principles. Here, the consent is vitiated on account of unsoundness of mind. And there lies the difference. If your consent is vitiated on account of, let's say, fraud or coercion or undue influence or misrepresentation, in that case, the contract only becomes voidable. In this case, however, this is a formative defect in contract, and therefore the contract does not only remain voidable, it becomes void, right? So whenever there's a dispute as to what happens, what is the effect of such a contract becoming, what happens to the fate of the contract, one can always argue that, you see, if you don't have the capacity to enter a contract, in that case, it suffers from a formative defect, and as much as the contract itself will be void, all bets are off, right? However, if it is voidable, then naturally it is at the instance of the party whose consent was so obtained, whether to go ahead with the contract or to resign the contract. Right? With that understanding, let's move on to the second component. Right? The second component is whether there was a lawful object. Right? Now, a contract has to have a lawful object. You can't, so just to give you examples, you can't enter into a contract to kill somebody. Contract killer is a void contract. There's no such thing as a contract. You can't enter into a contract for supply of drugs. Or, for example, let me put it this way. You can't enter into a contract for dealing in items over and above a prescribed limit. Let me give you a very interesting example. Yeah, Daniel Latifi's case. A person is traveling from, say, Dubai to India, or let's put it somewhere further, say South America. So some country in South America, he boards a flight. There's a certain time range, and he is carrying 15 kg of gold. Now, according to FEMA regulations, you can carry, at the time when the flight took off, the FEMA regulations stipulated that you can carry up to, say, 20 kgs of gold. So while the flight took off, he was perfectly within the confines of law. But at 12 o'clock here in India, there was a notification which comes out and which reduces that 20 kgs to 10 kgs. They say anything about 10 kgs will now become illegal. Now, as soon as the flight lands, the person is apprehended at the airport. The person says, but look here, this is a lawful contract. I was supposed to deliver these goods, and I had taken the the flight. And at the time when the flight departed, I was carrying gold within permissible limits. But as soon as the flight has landed, I am in a fix because now the law changed while I was in transit. Right? So there are two principles that apply to this. One, ignorantia juris non excusat. Say ignorance of law is not an excuse. Assuming that the law changed that very night, it would be applicable from that. Right? And you are presumed to know the law, irrespective of whether you are in a number two. That as on date, when the contract is being executed, it is for an unlawful object. It may have been lawful when the contract was entered into, but while the contract was about to be performed, the very object of contract became unlawful, and therefore it became void. Right? Now let's also deal with certain aspects of the matter, certain permutations and combinations, right? Because the definitions are very very, very standard, but how do you deal with those when it comes to real life cases? Now, you imagine a situation where you have entered into a contract to move, say, drugs from place X to place Y in Netherlands, right? And these are, say, permissible as per the laws of the Netherlands. However, what happens is that due to the consignment which is traveling from, let's say, one port to another, let's say in India to Netherlands, or whatever happens is that the ship or the vessel is stopped in India, where the laws do not permit such transit of drugs, because it is prohibited under the NDPs. Now, contracting parties may not live in India, but since part of the performance of the contract has happened in India, therefore the parties cannot file for enforcing or selling or doing anything with the subject matter of the contract in India. At least they may sue, they may do whatever they can in Netherlands, but they can't enforce that contract insofar as that contract remains in India. Let's say some of those drugs were perishable in nature. So under Sale of Goods Act, if something is perishable in nature, you can just buy it off, or you can sell it off, and from the proceeds of it, you can pay off the parties. But since it is in India and it's unlawful to carry drugs or transit drugs, then naturally you can't sort of enforce, right? So illegalities are those illegalities which may exist at the time of entering into the contract, or illegalities are also those illegalities which may happen subsequent to the execution of the agreement and during its performance. Right? Both these illegalities, without doubt, will render a contract void. Okay. Now, let's look at the essential elements of contract. First thing is an offer. Offer has to, of course, be distinguished with an invitation to offer. An invitation to offer may or may not result into an offer. Invitation to offer, by definition, is always vague. Right? So what do you mean when you say an offer? Then what, or let me put it this way, what are the attributes of a valid offer? The essential attributes of a valid offer is that it must be clear and specific as to three things. First, identity of parties. B, identity of subject matter. And C, mode of transaction. If your offer is clear on all these three attributes, then and only then it would be a valid offer. Now, all that I'm telling you are ratios of very celebrated cases, which I'm not taking you through because of the time constraints. I'm basically rushing you through it. An invitation to offer, in contradistinction, is an advertisement which is made to the public at large, which may or may not have all the attributes in respect of the identity of parties, identity of subject matter, and mode of transaction. If these three essential elements are missing, then it would, for all intents and purposes, be an invitation to offer and not an offer. For more details, you already know Carbolix Carbolix case, right? So you could understand it's a beautiful distinction which has been carved out, right? Now, in the smoke ball case, I'm not going into the facts because it's pretty much basic contract act, and I think I'm dealing with an advanced class of contract, right? So now let's come to the next element of valid acceptance. Acceptance is of two kinds. One, acceptance is by performance, or acceptance by conveying. Now, of course, acceptance and offer must be validly communicated to the other party. So if there's any distortion, if there is any loss of transmission, if there is any loss of postal delays, then all of that would render the communication bad in law. And if the communication of a valid offer and a valid acceptance is bad in law, then the entire contract falls like a pack of cards, right? Now, the parties must have consensus ad idem. Once you have a valid offer and a valid acceptance, this gives rise to consent. Consensus ad idem basically means that the parties to the contract must mean the same thing in the same sense. Another very important example which we used to read in law school was there was this horse called Black Beauty, right, which was sought to be sold off for a particular price. Right now, this was being sold off by a rancher who used to breed horses, and the person who was about to purchase that Black Beauty thought that it was that racehorse winner horse whose name was also Black Beauty, whereas the owner of the ranch thought that it was a previous horse who had retired, and he instead gave that horse instead of the horse which was the prize winner. And naturally, that rose into rescission of the contract. The person refused to accept delivery of the horse, or no, I think it was in that case what happened was the delivery was taken. It was during the tryout of the horse, the training, that they found out that the horse is an old horse and not the younger horse that they wanted to contact. So the question before the court was whether there is a consensus ad idem as to the identity of the subject matter. In this case, there was no consensus ad idem as to the identity of the subject matter, and therefore the contract was declared to be void, right? Suffering from a formative defect. I am time and again using the expression formative defect because this is an expression recognized by the courts in India, right? And you will find a good deal of judgments on this. Now, third, and of course most important, is mode of transaction. Now, if I say that the mode of transaction is going to, if the parties have agreed to the mode of transaction to be X mode, let's say wire transfer, and one of the parties instead goes and carries out a cash transfer, right? Then the question arises is whether the party who was supposed to agree to that cash transfer has in fact accepted. Because if it has accepted it, then that would give rise to a consensus ad idem situation. In case it refuses to accept it, then you would call it that there is a formative defect because there's no consent as to the mode of transaction. Now that we have understood the steps of entering into a contract, let's go to the second. Right? The next one is, of course, consideration. Consideration under 2(1)d speaks of the value, the underlying value. Consideration is something which is paid to or exchanged between the promisor and the promisee. And the value, the underlying value of the object of that consideration must have some value in the eyes of law. That is the requirement of it. It could be money, it could be barter, it could be, say, exchange of one good for another good, it could be shares, stocks, trades, derivatives, anything. It could be corporeal, incorporeal, it could be a right to collect rent, which could be transferred by way of consideration or by way of money, or you can pay money to assign a debt to somebody else, right? So it is not just, what I'm trying to tell you is that it is not just movable, immovable objects that are transferred or asked or could be held to be part of consideration. Consideration could also mean the right to collect something, right? Incorporeal rights, which you can't touch or feel, but which exist in law, right? So all those will also fall within the definition of consideration. Right? It is then and only then that there is a valid offer, there's a valid acceptance, there is valid consent, the contract is for a lawful object, and there is a lawful consideration involved, that all these 5 elements will give rise to an agreement. And if that agreement is enforceable by law, then voila, what you have is a contract between the parties. Now, there are certain agreements which are unenforceable. Now, those agreements I have already told you are void agreements if they perpetrate or the subject matter of those contracts is something which is unlawful or illegal. Right? And there is a vast sea of difference between the two expressions, unlawful and illegal. What is illegal will almost invariably entail a punishment as a consequence. What is unlawful is a bigger genus, of which illegality is a species. Now that we have dealt with all these factors, let's quickly jump to the performance of contracts, right? Okay. Now there could be special elements to a contract. Say one of the promise was that I want a painting to be made, and that painting has to be made by none other than the late Muhammad, late M.F. Hussain, right? Maqbool Fida Hussain. Now what happens is that, say, the contract was entered into on 1/1/2001, and the late M.F. Hussain passed away on 1/1/2002. The contract was for a set of 5 paintings to be delivered in during the course of the next 5 years. Now, in that contract, who do I sue and how do I recover? This is a contract which is inherently based on the personal skill of the promisee. And therefore, wherever contract involves an element of personal performance, then naturally I can't ask their legal heirs to do it. Right? All that can be done is, upon the untimely demise, the amount which has been, say, paid towards earnest money will be refunded and the contract will become, right? Because it has suffered on account of an impossibility to perform an act, right? And that is governed under section 56. Now, impossibility are of 2 types. Impossibility which existed at the time of entering into the contract itself. Let me give you a very interesting example that comes out of one of the commercial disputes that we had to deal. 2 parties to a contract, they were both companies, decided on an arbitration clause. Right? The arbitration clause said that, say, courts in Austria, Vienna will have jurisdiction, and the provisions of, say, particular arbitration act will apply, and that the Vienna Institute of International Arbitration shall have jurisdiction to decide the dispute through arbitration, and of course the award will be final. Right? That in so many words was the concept. Interestingly, there was nothing called Vienna Center for International Arbitration. There was an entity called Vienna Institute Arbitration Center, which was very different from whatever the name is. Now, this is an impossibility, because if there's a breach of the contract, where do you go and sue? Because the very place that the parties agreed to in the contract was not even in existence. Now, this is one form of impossibility. Second form of impossibility would be that at the time of execution, the place existed. Well, let me give you another example. Again, an arbitration clause, which said that Mr. Boutros Ghali, the former United Nations General Assembly Secretary, would preside over the arbitration. And when the breach happened, Mr. Ghali had passed away. Now, this is a subsequent form of impossibility. Now, in both these cases, Section 56 would squarely be attracted, and the parties would be discharged from performing any further their obligations. And if one of the parties have performed their obligations already, then the other party is to give them a monetary compensation for all the work that has already been done. Now, let's say it's many a times 56 is popularly called as force majeure, and force majeure is very important in the present context, right? Because we have just come out of a pandemic. I don't know whether it's pandemic still or endemic, whatever it is. The expression pandemic is now construed to be a part of drafting force majeure, which hitherto usually was not the practice. Even the central government has clearly earmarked that COVID-19 pandemic would be construed to not be pandemic, or to be construed to not be a category which would result in force majeure condition, right? Because many people would have otherwise terminated their contracts on account of COVID-19 existing. Now, when we talk of force majeure, what are the few principles that one needs to keep in? Number one, force majeure clauses are to be very strictly construed. Therefore, it means that the expression or the condition through which force majeure has occasion must obviously feature in the contract. Force majeure cannot be presumed to exist. It must be clearly written in the contract, right? For example, if you say wars, if you say cyclones, if you don't say flood, then on account of flooding, if your entire godown is inundated with water and you want to be discharged from the obligations of performing the contract, you can't invoke force majeure. So for force majeure to exist, it must be there in the contract itself. It's very, very vital. Number two, force majeure by definition must be something or some event over which the parties have no control. Because if the parties were able to control it or to even predict it, then force majeure will not come in the way. And the parties will have to perform. Okay. It's slightly, let me give you an example. Say the tsunami of 26 January 2001 was forecasted 3 days back, that there's going to be a tsunami in the next 3 days. You have a go down which is, say, about 2 kilometers from the beach, or about 1.5 kilometers from the beach. If you had prior information, then you could have availed it to move your goods from place A to place B, and you chose not to do it, then can you claim force majeure? You cannot. However, in another case, where, and this of course arose out of another contractual dispute in arbitration, that documents were being transferred from point X to point Y, and because of the WTC tower collapse on 9/11/2001, the documents could not be delivered in time. That was held to be a valid force majeure, right? Even though it did not form part of the contract, because that was on US soil. The Indian law and the common law that we follow clearly and categorically stipulates that force majeure has to be there expressly. It cannot be inferred, right? Either through the acts of the parties or by necessary implication. All right. So that's now. There are also those contracts where contracts are supposed to be performed jointly by parties. Now, if those contracts are to be performed jointly by the parties, then the obligation is on both the parties to, and let's say they fail in performing their obligations, then it is up to the person, the other contracting party, to sue and recover either from one or both or together, which is to say that the option to sue them jointly or severally vests in the other contract. Now, let's say in a case where there were 5 contracting parties and 4 of them decided to take it upon themselves while 5 wanted to be discharged. Then, of course, the 5th person can be discharged. And the other contracting party has every option to sue and recover the damages from the rest of the individuals. Now, there are certain contracts where time is of the essence, right? For those category of contracts, there must be a condition that time is the essence of contract, because it is only and only then that sections 46 to 48 and section 55 of the contract act will apply. If the parties say that time is not the essence of contract, then well, the parties must perform the contract within a reasonable period. Now, what is a reasonable period will depend on X factors, namely the market conditions, the business practice of those parties, the general market trend which is followed in those cases, right? So I think it's on account of all those attributes that whether it could be ascertained that a contract has to be performed within a timely manner or not is to be determined as a question of fact. Similarly, if there's a condition in the contract which says that this contract has to be performed in that specific place, and it has to be done. If it is not, then naturally it would be at the option of the party to declare the contract. Now, just because time is of the essence and place is of the essence does not mean that the contract, and if the person fails to honor it in a time-bound manner or fails to perform it at the place, that does not mean that the contract becomes void, or that the contract becomes non-enforceable, or the party could resign it immediately. It is only voidable at the option of the party. Sometimes you may say, all right, it's delayed by 2 days, but please get me my consignment. Right? So it's voidable at your discretion. You may choose to perform it nonetheless, or you may choose to terminate it. Otherwise, you can put your foot down and say, sorry, I resigned it, and I'll sue you for damages. Now, there is also something which is called, how do you terminate it? Now, in termination or rescission, as people understand, there are 3 specific attributes to it under section 62. 62 defines 3 attributes of contract that a contract can suffer three eventualities in such a scenario. There could be an alteration of the contract, there could be a rescission of the contract, or there could be a novation of it. Now, let me tell you in brief what all these three things mean. When you resign the contract, usually one of the two parties would resign the contract, and then the consequences follow. If there's a stipulation as a penalty clause that X amount of money would be paid as liquidated damages, then you pay the on account of unlawful termination or unlawful rescission. So rescission, the act of rescission, is a question of fact which is to be proved. Second, the consequences of that rescission must also be established. Say there was loss of business. I wanted delivery of goods. You could not pay me, you could not deliver the goods to me, because of which my other customers are suffering, because of which I now don't have 5 different businesses which hitherto were coming to me, because I lost their confidence. So that's essentially loss of business. Many times parties can agree to not have a particular clause. Say parties hereby expressly undertake that they shall not claim loss of business, which will otherwise, or let's say for all intents and purposes, liquidated damages which have been expressly agreed to by and between the parties would also take within its ambit any loss of business which has occurred. And so the parties may choose what kind of remedies they want to enforce. That's the beauty of it, right? But the right to sue for termination, and because that happens a lot in many contracts, the right to sue for termination cannot be taken away. There are many a times when contracts are drafted where only one party can terminate a contract, because those are of course hopelessly one-sided contracts, like click wrap agreements, like signing on those dotted lines, like builder buyers agreement, where only one person has the right to terminate the contract, the other person has no remedy. Does that mean that the person does not have a remedy? The answer is a resounding no. The Supreme Court has in Pioneer Urban, in Unilever, in MK Lucknow Development Authority versus MK Gupta, so many LK Gupta, sorry, has held in so many decisions that in such scenarios where parties are made to sign on dotted lines, or or click wrap agreements, where all you have to do is just click on one thing, I accept, and everything is deemed to be accepted, right? Those kind of contracts hold no value. The parties can always get out of those contracts and sue for wrongful termination of the contract, even if there is no clause which authorizes them to terminate the contract and then sue for damages. Otherwise, in absence whereof, if it could be established that both the parties entered into the contract with open eyes, then of course the other party which is now suing for damages can be precluded from doing so. But your right to sue cannot be taken away, right? And that applies across board. Let's say two people enter into a contract and say that on from this date we shall not register an FIR against you. That contract is non-enforceable. Why? Because right to register an FIR is your right under 154, and in terms of the judgment of the Supreme Court in Lalita Kumari 14 to SCC 1, right? So you can do it. There's no stopping you. So any contract cannot preclude you from raising any right, which is otherwise. Contract can't stop you from invoking an arbitration clause. Contract can't stop you from invoking any other relief under any other law for the time being. If there is a contract to that effect, then that particular condition of the contract is void. If the entire contract is contingent on that condition, then the entire contract is void. Right? Now, there are certain elements of contract which apply to a scenario where, say, a contract is performed, and one of the parties has decided to terminate the contract after taking the benefits. Let's say I receive the goods and then I say, oh, poor quality goods, I terminate, but I retain the goods. In that case, my intention is of course malicious. If I hold my goods, I terminate the contract and I don't even pay you the money. Either I return you your goods or I ask for money. I do neither. I just hold a lien on your goods. without any condition. I could, of course, I'm entitled to hold lien on your goods when I say that, look here, pay me until X date. Otherwise, I will sell those goods and recover my money. I don't do either. In fact, I have not even paid any amount. I have just taken goods and I have said on those goods, right? In those cases, a party can be compelled by the court to deliver up the goods, right? So those kind of contracts are uberima fides contracts, which is to say that you cannot be allowed to unjustly enrich yourself at the expense of something or somebody else. You can't have it both ways. Either sue, recover your money, or you deliver back the goods and then take back your money. You can't sit on it, hold it indefinitely under a lien, impose no conditions whatsoever, and say, all right, I terminate. Understood? So all these are aspects of. Now let's talk a bit about specific relief. Yeah. Another specific relief act. Let's understand first. Asking for a specific performance of contract is discretionary remedy. You are not entitled to it. You have to, of course, establish it's the discretion of the court whether to give you that remedy or not. The basic principle of such contract is that if that contract is, or if the breach of the contract could be compensated adequately in monetary terms, then the court will never allow a relief for specific performance. The court will only allow specific performance in cases where the court feels that after the breach, the party cannot be adequately compensated. And it is only in those cases that the court will allow a plea for specific performance. Now, the party has to establish that I am willing and ready to perform my part of the court. Readiness and willingness is the sine qua non for a plea of raising specific. If I don't raise that plea of in my plaint or in my counterclaim or whatever it is by some, and also leading evidence. Say if I say I'm ready and willing to give 2 crore rupees, but he has not delivered the car yet. So please kindly direct him to send me the car because this is a customized car. Okay. Then I can claim. I'm not saying that the court will grant it, but I can always claim. Now, if I'm saying I'm ready and willing, then I must have done something towards that. If I have put, let's say, a demand draft of 2 crore rupees and annexed it, that look here, I also sent that demand draft to him, he refused to accept. And that shows my readiness and willingness to perform my part of the contract. All I'm asking him to do is to perform his part of the contract, and since he has refused to perform his contract, I have approached the court, directing a relief by way of specific performance. Second thing that is a usual, another topic which is often litigated is transfer of immovable property. Say people enter into a contract for an immovable property. Of course, in terms of Section 17 of the Registration Act, it's a compulsory registrable document. You have to go to the registrar and get it registered. The parties have signed, but the other, and also the money has been exchanged, but the other party, which is the seller, is now refusing to come to the registrar's office to get the document registered. So what is your remedy then? Your remedy then is specific performance of the contract. Therefore, you would see in many of those sale deeds or lease deeds, you would have a specific recital that the first party, or let's say that the seller undertakes to make himself present on such date as may be mutually agreed to between the parties, to and do such acts as may be necessary for the smooth transfer of the property, or in other words, shall be present before the registrar's office on such day and on such time as may be intimated to him in this regard. Those are clauses which are now making their way into sale deeds, right? So if a party refuses to do that, then you can always claim specific. However, in this case, if somebody were to appear from the opposite side, they can say, all right, if I'm not in the mood to do it, you may take back your earnest money and you may take whatever interest you want to charge. Right? That's another way to argue. Therefore, I'm saying specific performance is absolutely discretionary. if the court feels that this must be given to you, that particular relief must be given to you, it is only then that the court will allow to claim specific things. Like, there are also 4 more small issues that I wanted to flag insofar as specific performance is concerned, which I think are usually questions. Now, what happens is, in some cases, specific performance can happen of a part of the contract. And for the rest of the part of the contract, which let's say could not be performed for whatever reasons, what the court usually does is that the court allows money to be paid to the party. However, as a general rule, under Section 12 of the Specific Performance Act, the court will generally not allow somebody to only perform part of the contract. Court generally says perform the contract in full. You can't say I am only, I was supposed to give 2 crore rupees, I have only paid 1 crore, 1 crore. Or let's say if I was supposed to deliver immovable property, I have delivered only half of the survey number and half of the survey number I have written. The court does not want to enter into those nuances. If there's a contract and if it says that it has to be performed in full, then it will be performed in full. Now, let's say in a situation where you have already sold part of the property to somebody else. In that case, you are entering into another title dispute. So in order to eliminate that title dispute, the court will say, all right, at least this much property is unencumbered. You have not transferred it to anybody else. Give this much property to the person, and for the remaining half, pay damages. But that is, of course, molding of relief, and usually in extraordinary circumstances that the court will do. The court will not regularly or generally resort to this. Right? As I said under Section 14, a specific performance of a contract will never be sought for or could never be allowed by the court if adequate monetary compensation is on the cards. So let's say there's a clause in the contract which says that you can be compensated adequately because there's a liquidated damages clause. Then the court will not direct specific performance because there's already a liquidated damages clause. And therefore, a defendant in such a case must raise this as an objection that, my lords, I'm not compelled to perform it because there's a liquidation. Let him sue and ask for damages. Right? Readiness and willingness of in a plea for specific performance comes out of Section 16C. The readiness and willingness has to be demonstrated. Right? And as I already said, Section 20 talks about the discretion of the court. So the relief itself under specific performance of the contract is discretionary. Now let's talk about other things. Let's talk about certain other acts that apply to such scenario. You can also ask, let's say in a case that I just shared with you some time back, which was that part of the property was already sold to somebody else. Now, what happens in such a case? Now, if you are hell-bent on specific performance, what you can seek is a relief for cancellation of the sale deed which was entered in. Right? Provided, of course, you are within limitation. Because under Article 58 of the Limitation Act, such relief can only be sought within a period of 3 years from the date on which the right to sue first accrued. Right? So you have different competing remedies. You can either choose for a specific performance. If there's a liquidated damages, then you invoke that clause also. You can't ask for part performance. So in order to get out of that obstacle, what you can do is you can seek for cancellation of the instrument of transfer, sale deed or lease or whatever. Right? Of course, subject to limitation. 3 years from the date on which right to sue first. So let's say if on 1st January 2010 you were aware that part of this property was sold and you decided to file your suit in 2013, right? And in 2014 you asked for another, by amending your complaint under 617, you also asked for a further relief to cancel the sale deed. Then that particular relief is time bound. Right? So while you are making your plaint or while you are putting forth such enforcement, you must also be alive to the requirements of limitation act. Right? So I think that should basically, how do I say? I would just call it a bird's eye view of contracting specific relief, only in context to the Contract Act. I'm not dealing with specific relief act as it applies to injunctive reliefs or as it applies to property disputes. But if you would like me to deal with that, I can do that in another 5 seconds. Whatever is fine.
Yes, sir. Sure, definitely. We would love to hear more from you if you have the time.
Right, surely. So, okay. Injunctive relief. 39(1) and 2 is for temporary injunction, right? But a specific permanent injunction can only be claimed under Chapter 4 of the specific. Now, for claiming injunctive relief, you have to, of course, establish prima facie case, balance of convenience, and irreparable injury. It is then and only then that injunctive relief will be given. Again, injunctive relief is also discretionary. You can't claim it as a matter of right. Now let's talk about, and this is of course governed under section 36, 37 of the Specific Relief Act. Insofar as Order 39 Rule 1 and 2 is concerned, then 39(1) deals only with immovable and 39(2) deals with character, personally, or any other legal right apart from immovable property. In many plaints, I've seen that people wrongly say 39(1) and 2 as a matter of, just principle. But you must see that when a property is in the nature of a movable property versus a movable property, which clause are you invoking? That becomes very, very important. Now, dealing with declaratory reliefs. Insofar as section 34 and 35 of Specific Relief Act are concerned, a declaratory relief can be claimed not only in respect of a movable property, but in respect of any legal right or character of a person. Let's say you can ask for a declaratory relief to annul a particular arrangement. You can ask for a declaratory relief that such X thing is a wager. You can ask for a declaratory relief that I be declared to be the sole owner and exclusive owner of this property. There could be a declaratory relief to say that this particular transaction is void. So there are so many types of declaratory decree that you can see. In fact, declaratory decrees pre-exist the Specific Relief Act of 1963. In fact, the courts and Privy Council used to issue what they call declaratory writs. So even today, the Supreme Court of India and High Court also can, in their respective powers under Article 32 and 226, have the right to issue declaratory writs. Now, of course, if it's a dispute between two individuals, then you will not naturally knock at the doors of High Court or Supreme Court, unless, of course, it meets the pecuniary standards of High Court. But for all intents and purposes, you will approach the lowest competent court under Section 16 of CPC. So when you have approached the lowest competent court, you can seek for that declaratory decree. To grant or not grant that declaratory decree is again the discretion of the court. But I think what is also more important is Section 35 of the Specific Relief Act, because Section 35 of the Specific Relief Act says that the decree which is passed by the court shall apply to all the parties to the suit. Right? So if there are 20 parties to the suit, then that declaratory decree will apply to all the 20 parties of the suit, so that none of the parties could thereafter go and raise a question by filing another suit in respect of the same problem. Otherwise, of course, it would be barred by principles of res judicata, issue, estoppel, and so on and so forth. Right? So I think that's that.
Sir, thank you so much for this insightful lecture. I mean, this lecture has definitely beautifully captured the essence of Contract Act and Specific Relief Act. And if you have a few more minutes, we would like to take up a few questions that we have received from the attendees. Right, sir. So the first question is with respect to preparation. So when we think about Contract Act or contract law, it is often identified as a subject which is easier as compared to other subjects. But like your lecture, anyone who has attended your lecture will know that it is the situations that make the applicability of the act an effort. So when it comes to preparation for judiciary, and as you have also coached students for competitive examination, what advice would you give to these aspirants, and what are the key areas that they should specifically focus on?
I think the first thing that they should bear in mind is to have the ingredients of every provision on the definitions. Nobody would expect you to remember the definition. Although sometimes I've seen very less than desirable questions which say, so uh, rescission of the contract is under which section? You will get those sitter questions also, which is very. But most of the questions, or whatever the trend that I'm looking at, is that there is a gradual shift towards application based questions. So unless and until you know the definition, you would not be able to identify as to how to apply it. Secondly, you must always be on an active lookout for those words which are being conveyed. Let's say, for example, somebody understands the contract could only be one piece of paper at a time. Sometimes contracts are orally, sometimes various correspondences may also give rise to one. So I think what is essential in terms of competitive examination is the formation contract. That's very, very important. How contracts are to be performed. Secondly, third is the essential ingredients. If you have a good command and mastery over all those aspects, then I think it's going to be an easy, breezy trip.
Right. So the next question is with respect to arbitration agreements and ordinary contracts. What is, if we were to identify the material difference between the two, what would it be?
See, arbitration agreements by definition take you to a customized court opted by the parties, and the award will be final and binding on the parties. These three or four elements are the basis of an arbitration. Now, of course, if the dispute is inherently non-arbitrable, then despite the existence of an arbitration contract will not make the dispute arbitrable. So you have to see whether the dispute itself is arbitrable. Say, for example, a question involving complex financial transactions may not be arbitrable. A question alleging oppression and mismanagement may not be arbitrable. Right? So in those cases, whether it is arbitrable or not is also. However, those questions could be effectively adjudicated by competent courts and tribunals. Why I'm saying tribunals also along with court is, let's say there's a contract, it has an arbitration clause, but the remedy lies elsewhere. Say the remedy lies in NCLT. And Section 430 of Companies Act clearly says that civil courts shall have no jurisdiction. Then your invocation of arbitration, you running helter-skelter in courts of law is not going to give you any remedy, because the remedy, if any, exists before the NCLT. So you have to look at that. Next, I think, is the nomenclature. What the arbitral tribunal or arbitrator gives you is an award. The court's pass is a decree. Of course, an award shall, for all intents and purposes, be a deemed decree of the court and shall be final and binding, right? In terms of Section 35 and 36 of the Arbitration Act, 1996. However, these two factors are very, very different, right? So you can easily identify the quotes from arbitration process. I think if that was the question.
Yes, yes. Thank you. Thank you so much, sir. One final question, which we've received from our YouTube comment section. If I understand the question correctly, it pertains to the change of law when a vessel is crossing the Indian borders. What happens when the law changes at that moment?
Then that law governs.
Right. Right, right. Thank you. Thank you so much, sir.
You're taking a plane or whether you're going by sea, the mode doesn't matter.
Right. Thank you. Thank you so much, sir. It was indeed a pleasure to hear you and to get insights from you about contracts and specific relief. Thank you for your time. I understand you have a busy schedule, and thank you for spending some time with us on this Saturday. With this, we come to an end of the eighth lecture of the series. And I, on behalf of my team, am grateful to Advocate Saxena for kindly agreeing to deliver today's lecture. Sir, we look forward to hosting you again soon. Tomorrow,
Absolutely. It's my pleasure.
thank you, sir. So tomorrow we will, in fact, begin with our final phase of the lecture series, which is which we will the details of which we will share shortly. And before we conclude today, I would just like to present a short vote of thanks to everyone who has been instrumental in conducting the lecture series so far. To our Vice Chancellor, Sir Professor Dr. C. Rajkumar, for his vision and his unrelenting support for the lecture series, to our Executive Dean, Professor Dr. Srijit, for his leadership and his passion to provide the best of opportunities to JJLS students, to our JJLS program directors, Professor Karan Latayan and Professor Manveen Singh, for their kind guidance throughout the planning and preparation of the lecture series, to our guest speakers for the lecture series who have kindly agreed to spend their valuable time and gratify our students, to my colleagues, Ms. Pratibha Tandon, Ms. Shambhavi Shivani, Ms. Ashwati Nair Suresh, and Professor Mukesh Arora, Assistant Deans of Career Services, whose sheer dedication and commitment has resulted in flagging off this initiative and carrying it forward so successfully. And not, last but not the least, to our graphic design team and IT team for their continuous logistical support. Thank you all. Thank you, sir. See you tomorrow.
Thank you. Bye.